Good morning, everyone. Thank you for being here. My name is Greg Bowman, and I have the honor and the privilege of serving as the Dean of the WVU College of Law, and I'd like to welcome you to today's Law Review Symposium on Education Law at the College of Law. West Virginia University is a public land-grant institution of higher learning, and we are proud of the role that we play. And at the College of Law, we are proud to be part of this great comprehensive university and proud to be training lawyers and leaders for the future. And as all of us who have dedicated our careers to education in this room, we do all know, I think, that we are at a pivotal time in the history of our country for education and for the values that we hold dear and that are embodied in education at the primary and the secondary levels and higher education. So, really important topic. We could not have timed things better. You only time the market by accident, and we had a teacher strike again this week. But with the 40th anniversary of the Paulie decision, with last year's teacher strikes in West Virginia, that became a leading moment in the nation. And then again, this year we have a lot to talk about, and it's an incredibly important topic. And we have educators and lawyers from across the country who are with us here today. We welcome you, and we look forward to having the conversation about this topic today. I want to thank a few people before we begin. I want to thank my colleague Josh Weishart, who has been really spearheading the planning for this symposium. Also my colleague Sean Tu, our Associate Dean for Faculty Research and Development. Staff who have been centrally important in putting together this detailed event today, and also the students of the Law Review. Law Reviews are student-led, they are student-run, and they're a really wonderful part of any law school in the U.S. and certainly of our law school. So we thank them very, very much. So thank you for being here. I look forward to a wonderful program today, and I will turn it over to my colleague Josh.
Thank you, Dean Bowman, and thank you all for joining us. Well, like most academics, I find it difficult at times to get people interested, much less excited about my research. No matter how many times I tweet and retweet and share and tag and hashtag and whatever one does on LinkedIn. I've used all manner of clickbait and even video promos and for old schoolers, the traditional op-ed. But I'm not going to stop because the subject of my research is education rights and state constitutions. And damn it, that really is important. We tend to think of the U.S. Constitution as the repository of all of our rights, when often it provides just a floor of constitutional protection, and state constitutions set a higher ceiling of safeguards. And the space in between is filled with all sorts of possibilities. Well, we've assembled a panel of preeminent national experts and practitioners who are as convinced as I am of the importance of state constitution education rights. And perhaps by the end of this discussion, you will be as well. Scott Bauries is Associate Dean and Professor of Law at the University of Kentucky College of Law. He is the author of numerous law review articles, books and book chapters on, among other things, state constitutions and education law. The Education Law Association recognized Scott's exceptional work with the Joseph C. Beckham Dissertation of the Year Award. In a former life, Scott taught English and coached soccer for several years in both public and private school in Florida. He was also a school district administrator and curriculum developer. Add to his frontline teaching and administrative experience, Scott has a PhD in educational leadership and policy, and he also earned his law degree from the University of Florida. And I'll say on a personal note that Scott encouraged me early on to pursue my interest in education rights and has been a constant source of support ever since. Mark Dorosin is the co-director of the Julius L. Chambers Center for Civil Rights, a nonprofit law firm focusing on housing discrimination, environmental justice, political participation, and racial disparities in education. He's also an adjunct professor of law at UNC and a chairman of the Orange County Board of Commissioners. For nearly 10 years, Mark was a managing attorney at the UNC Center for Civil Rights until the Board of Governors banned the center from engaging in legal advocacy because it was just too effective at advancing the cause of civil rights. I imagine Mark wears that as a badge of honor. Mark earned his law degree from the University of North Carolina at Chapel Hill, and he has a master's in history as well. Zoe Savitsky is the Deputy Legal Director for the Children's Rights at the Southern Poverty Law Center, where she oversees litigation and policy work focused on guaranteeing vulnerable children access to educational resources and health services. Zoe's previous experience includes serving as a civil rights attorney in the Educational Opportunities section of the Justice Department, where she focused on developing the DOJ's school-to-prison pipeline practice. Zoe is a Harvard graduate, and even more impressive, she earned her law degree from the University of California, Berkeley School of Law, my alma mater. David Sciarra is the executive director of the Education Law Center in New Jersey, which works to improve educational opportunities and outcomes for low-income students, students of color, and students with special needs. I don't mean to age you here, David, but you were litigating cases before Pauley was decided 40 years ago in 1979, and before I was born that same year. Yes, for my students in the room, Weishart at 40. David has litigated to enforce access for low-income and minority children to equal and adequate education until under state and federal law. He served as a counsel in New Jersey's landmark education rights case, Abbott versus Burke, which the New York Times described as the most significant education case since Brown versus Board of Education, and second only to Pauley. That's my ad lib. David has served on the Federal Education Equity and Excellence Commission, authored numerous publications on school finance, educational equity, and assisted as consultant or co-counsel on several pending school finance cases. David is a Berkeley graduate as well, and he earned his law degree at Temple University School of Law. Please help me welcome our panelists. So based on feedback from our panelists, I'd like us to think about this discussion with three broad themes in mind. So first, what is the nature of the right to education? What purpose is it meant to serve? And is it currently serving that purpose? Second, what's the role of courts in enforcing the right to education? And third, the political and social forces that are shaping the future content and scope of the right to education. What will be the remedy in the cases that come? And to make some headway on that first theme, let's begin with Pauley. We had an excellent panel discussion yesterday on Pauley's lasting influence on West Virginia education law and policy. But today, we will think about Pauley's influence far beyond West Virginia. And David, you have witnessed firsthand the progression of education rights cases in state courts. Can you help us situate Pauley in that historical context and tell us what you think is distinct and influential, even today, about Pauley's conception of the right to education?
Okay, so thank you. I hadn't looked at Pauley in a while until the other day, preparing for this event, and I didn't realize it was decided in 1979. I thought it was later than that. So I was kind of surprised by that. So historically, in terms of the development of education rights in the courts, Pauley is really a bellwether, actually, case in the country. Up till that point, there had been litigation in the states, Serrano versus Priest, Robinson versus Cahill in New Jersey, and other decisions. But those cases were really focused a lot on dollar equity, what we call fiscal equity, trying to equalize resources across districts. It was a lot about the money in the system, the reliance on the property tax and so forth and so on. And Pauley comes along and really kind of, breaks through to a whole nother level. So if you read the decision isn't so much about dollar inputs. I mean, there is discussion about the formula and the disparities that the formula creates and the need for the court on remand to look at the reliance on local taxes and the extent to which the state is putting in money and so forth and so on. But the court's articulation of what a thorough and efficient education means for West Virginia school children, which is your standard in your Constitution, similar to New Jersey's, by the way, and Pennsylvania's, that the state has to, essentially the legislature is responsible to provide a thorough and efficient system of free public schools. It's a kind of common formulation of education rights in a number of state constitutions. The court's definition of that, putting the sort of meat on the bones of what a thorough and efficient education means, when you think about it in 1979, is frankly extraordinary. It's a bit of a precursor to cases that came along right after that, Abbott versus Burke, which was decided in the late 80s and then went up to the New Jersey Supreme Court in '91, and of course the Rose case in Kentucky, which Scott will talk about. Those are a decade later and follow on and build really on the foundation that Pauley put down. And just a couple things about the court's definition of what rights West Virginia school children are entitled to under the thorough and efficient clause here, because it's not only important, obviously, for children here, but also, as I've mentioned, had significant implications on the development of not just education rights but education policy over the following 2 decades into this day. So the court talks about, first of all, education being a fundamental right, which is really important. So it's not, the court declares that the right to education is fundamental, which means that the court is going to, as you know, courts are going to look at challenges to state statutes and state policies at a heightened level. But more importantly, the way they define what a thorough and efficient education has to include is really, as I said, a precursor to what we saw develop in the 90s, decade and a half later, around standards-based education. That came in full bloom under No Child Left Behind. So the court talks about the development of each child and his capacity to literacy, mathematics, knowledge of government, self-knowledge, and knowledge of his total environment, to allow the child to intelligently choose life work and know his or her options, work training and advanced academic training as the child may intelligently choose, recreational pursuits, interest in all the creative arts such as music, theater, literature, and the visual arts. I love that one. And social ethics and so forth and so on. And then also, important services, which often gets lost in the discussion about space and facilities, good physical facilities, instructional materials, and personnel. And finally, that the state has an obligation, the court is saying, to make sure that the resources, that there's the capacity to use the resources in the system at the local level effectively and efficiently. Well, there you have it. So this is a court, this is a decision that's not about basic skills. That's not about minimally adequate. Sorry, South Carolina folks that are here. Not about a low bar. This is about a well-rounded, rich, and rigorous curriculum that gives kids a meaningful opportunity to learn in a variety of subject areas, not just mathematics and English language arts, which is the usual focus, but social studies, civics, citizenship, the arts, all of the things that tie children to school that are so important. So this is a definition of a well-rounded education that the state has to provide kids, and it's got to do it in buildings that are conducive to learning, to providing and delivering this education. And the state has the ultimate responsibility, as the court says, I just love this, careful state and local supervision to prevent waste and to monitor pupil, teacher, and administrative competency. So, to just finish, Pauley's influenced then this definition then, you see it then take root in cases like Rose and Abbott versus Burke, and fast forward other cases that are more recent, Kansas, the Gannon case, and these cases in various states, and even today, cases that are being brought now, such as in Pennsylvania, the William Penn case, which is going to be going to trial soon, so forth and so on. These are all about not just looking at dollar inputs, how much money is going into the system, but is the system responsive to student need? Is the system providing a full, rich education to children that prepares them for citizenship, prepares them to be productive contributors to the economic life of a community, and so forth and so on? And is the state really providing all of the resources that are necessary in order to enable children to achieve? The last thing I'll say is that this is a precursor to what happened in No Child Left Behind. You know, when you think about this, No Child Left Behind was the point at which the federal government said, look, if you're going to get federal money, this is in 2000, states have to put in place curriculum content standards, performance assessments, and accountability measures. They left off resources, unfortunately, which is why, which is still the problem, right? They didn't talk about opportunity to learn, the resources that would give kids opportunity to learn. But the point about that is that Pauley really was a kind of touchstone for what happened with standards-based reform in the United States, which is that the states no longer, in the implementation of their constitutional obligations, were going to just sort of sit back and, as they had for decades, delegate the sum and substance of education to local school districts. And that's what states did prior to Pauley. They basically said, you know, the local districts, curriculum, whatever you, testing, all of these things, and even money, because a lot of these formulas relied on local money, the sort of state delegating its constitutional obligation down to its local constructs, the school districts. And what Pauley is essentially saying to the state is, no, you're not going to do that. This is the definition of the education that all West Virginia children are entitled to. And the state has an obligation to ensure that its local school districts, which it controls, which are creatures of state policy, are meeting a rigorous, robust definition of what a thorough and efficient education is. So this is a real sort of breakthrough in not just education rights development, but education and policy practice across the sort of American landscape.
Right, and as you said, it was ahead of its time in its conception of the right as it containing both an adequacy component and an equity component. And as you pointed out, it continues to be relied upon and cited by other state courts even today. Scott, I want to bring you in there. Your scholarship has paid careful attention to the text of state constitutions and judicial interpretations of the text. Tell us how Pauley stacks up among the cases you've studied.
Okay, so I don't know if this is on, but yeah, it is. Okay, so in my initial response to the email, after I read Pauley again for the first time in a long time, I've been writing about these cases for over 10 years now, and Pauley was always sort of like a signpost along the road, and it had been characterized, I think, inaccurately as a pure equity case during the time when people were characterizing these cases. There were a series of I guess probably the first one to really put the flag in the ground on setting down waves of litigation was our general counsel at University of Kentucky, Bill Throw, or one of the early ones anyway, one of the ones that gets most cited. And so the metaphor that he either borrowed or came up with in that article states that there were 3 waves of school finance litigation. Now, we're all sort of skeptical of this characterization now, but it's helpful in figuring out how Pauley was mischaracterized and how I've come to see it today. So the first wave was in federal court, that if you're familiar with the case San Antonio versus Rodriguez, which held that education was not a fundamental right under the federal constitution and that wealth was not a suspect classification under the Equal Protection Clause, and therefore basically approved Texas's wildly unequal school funding system, or at least allowed it to go forward. That shunted all school finance litigation, at least for a time, into state courts, where originally, I've argued due to path dependence, we proceeded along those claims in the same way that Rodriguez attempted to proceed. We tried to put together equal protection claims based on fundamental rights and suspect classifications. Some of them succeeded, some of them failed. Everybody up until recently sort of put Pauley in that category, because Pauley talks a lot about equality, but Rose talks a lot about equality as well. As Josh has argued very persuasively, equality and adequacy are not really separable concepts. You know, they're interlinked with each other. But Pauley probably should have been characterized as sort of a fulcrum between equality and adequacy in that early scholarship, and I think people are starting to see it that way now. So there's two reasons for this. One is that Pauley is, along with Robinson versus Cahill, which in New Jersey, which was a case that was purely along the Rodriguez line in terms of the way that it was originally litigated, but it also took state constitutional language seriously. Pauley takes the state constitutional language seriously, tries to figure out what it is that thorough means, what it is that efficient means, not just looks at the school system and says, this is bad, let's find it inadequate, like a lot of cases seem to do in the sort of latter era of the adequacy wave. So Pauley was originally placed in this category of equality cases that were sort of Rodriguez copies, but I would argue that it actually is the beginning of the adequacy wave, such that there is one in school funding litigation, and that there would be no Rose if there was no Pauley. Pauley sort of laid the groundwork for Rose. So we're at Pauley at 40 right now. We're also at Rose at 30 right now, and Bauries graduating from high school at 30, right? Josh at 40. Right? So that's where we sit, right? And so Rose, when you read Rose discusses Pauley at great length as sort of the governing precedent in the area. So this is really interesting, because this is something that doesn't happen in federal constitutional law, but does happen in state constitutional law. In federal constitutional law, if one of the justices said, well, France does it this way, and France has similar language in its constitution, and France interpreted that language to mean X, so we should defer to that, or at least find that persuasive and interpret our constitution to also mean X. That would light people's hair on fire. People would be apoplectic if the Supreme Court did that. And yet, in state constitutional law, we have a bunch of quasi-sovereign entities, each of which has its own constitution, and they constantly borrow from each other, not just in interpretation, but in language. You have thorough and efficient clauses in 6 or 7 different state constitutions, and they clearly read each other's constitutions and borrowed that language from each other, right? Which is really interesting, right? It means that they're not situated the same way as the United States and France. They're kind of situated in sort of a similar way to the common law courts in the United States, right? So they borrow not only language from each other, but then they look at that language and see how each other interpret that language, and then they defer to interpretations of that language the same way common law courts would do throughout the United States of America. And Pauley began that sort of methodology in the area of education clauses. It relied a lot on the New Jersey case and looked at what the New Jersey case did with its thorough and efficient clause, and both as to justiciability and as to trying to figure out what the role of that clause was in the case, and used it the way a common law court would use persuasive authority, which would be highly controversial if we did that at the federal level. Okay? So that's point one, I think, about why Pauley is important. Point two is that Pauley also analyzed lots of other stuff besides text. In addition to looking at precedent, Pauley analyzed the school system in general. It didn't go as far as the Kentucky Supreme Court did, because Pauley was a remand. So the Kentucky Supreme Court in Rose ended up adjudicating the entire state system to be unconstitutional as a matter of Supreme Court precedent, and based a large part of its decision on testimony of experts like Curran Alexander, who testified in the case about what the meaning of the Constitution should be in light of education practice across the country. That's not something you see in Pauley, and actually I think that is something that is one of the things that made me skeptical about Rose and makes me like Pauley better than I like Rose as a matter of constitutional scholarship. But Pauley put the flag in the ground that we have to take state constitutional text seriously and try to give it operation. Now, I think one thing to think about going forward, if we want to talk about other cases in the panoply of school funding litigation, is that Pauley had some pretty good language to work with. Pauley wasn't trying to define the term sufficient or ample or high quality. Pauley was trying to define the term efficient, which has a very well-recognized meaning, and the term thorough, which may not have as well-recognized a meaning, but it certainly doesn't mean minimal, right? In any dictionary that you consult, thorough does not mean minimal. It does not mean basic. It means fully comprehensive or something close to that, right? So Pauley was working with some very good constitutional language. I would argue, and we can talk more about this later, but I would argue that other state Supreme Courts are working with language that's a little bit more difficult to place a real meaning on. So.
Yeah.
So just in the interest of making this more of a conversation, I really appreciate the point that Scott's making about that transition from equality to adequacy and Pauley being the fulcrum. I think what we're seeing now in the current era or the later era, at least in North Carolina particularly, is an effort to try to bring some of that equality discussion back into this these school financing cases, particularly because what we see is that the disparities that are produced by the funding inequities fall particularly hardest on students of color, low-well students. And so in North Carolina, for example, in the Leandro case, one of the things when we actually intervened in that case on behalf of African-American parents and students in the Charlotte-Mecklenburg school system. And one of the goals was to use the language of Leandro about, which in the North Carolina case made a particular reference to at-risk students, defining them, students from a low-wealth family, participants in a free and reduced lunch program, limited English proficiency, a single-parent household, and that those students were particularly being failed by the North Carolina funding model. So one of the things we were trying to do, and we've continued to try to do, not as successfully as we'd hoped, is to bring that equality piece back in and to say that, again, as a fundamental right, so you've got this heightened scrutiny, to highlight the racial disparities in particular without having to go through the equal protection argument of proving intentional discrimination. That's proved harder to do, but I think at least what we've been trying to do is bring some of that equality aspect back into the discussion. So I really like that framing, and I think that's going to be a critical element, at least in North Carolina, in helping move this forward.
Another way to frame this, and Zoe, you noted that Pauley doesn't focus on one word in the education clause, in the West Virginia education clause, a word that you believe is critical in terms of the purpose of the right to education, and that word is free, right? So can you explain the significance of that word?
Sure. So I'm going to do something that I would tell my staff and certainly law students to not do, which is I'm going to read some stuff. I'm going to try not to just read at you, but I want to not forget the points that I wrote down because this is an emerging area that we're focusing on. So please do not follow my example. Just to frame a little bit what we, the Southern Poverty Law Center, are doing on this panel of distinguished education lawyers and scholars. Southern Poverty Law Center is a civil rights nonprofit based in Montgomery, Alabama, and we fight for the rights of vulnerable folks, especially children, across the Deep South. So I lead our children's rights work in that region, and we have identified 3 primary areas of focus: stopping the school-to-prison pipeline, fighting for educational equity, and protecting children's access to health and mental health services. So this conversation today is very much in the bucket of educational equity, which we think of as basically having 3 key components. First is access. Can you even enroll in school in the first place? Are you prevented via segregation, via discrimination, et cetera? Once you do enroll, what do you receive? Do you actually receive a quality education, and is that quality differing based on a protected status? And then the third component is really thinking about how do we protect our system of public education? Public education, I'm sure it's no surprise to anyone in this room, is under attack by the forces of privatization, both here in West Virginia and across the country. I was fortunate last night to hear from your own Professor Taylor that the teachers in this state are continuing to protect the public in public education, and that thus far you have beaten back efforts to privatize your system. So West Virginia leads the nation in that regard, as I'm sure many others. This is my first trip to West Virginia, so you'll have to educate me later on the other ways in which you lead the nation. But the word that was mentioned that I do think is very important to think about in this context is free, because the freeness of public education is one of the most common components of state education clauses. There are 11 clauses that use the phrase thorough and efficient. There are 26 that use the word free in describing public education. It is an incredibly important component of what we think of as public. So thinking first about the history of free schools in this country. Prior to the American Revolution, there weren't really any free schools. After the Revolution, there were some common schools established, mostly in New England, and some of them were free. For the most part, they were not. And even the ones that were free, of course, did not educate women like me or people of color, really anyone except white men. And so it really was not until the Civil War and the Reconstruction era that we began to have a system and a value of free schools, although to give credit where credit is due, a gentleman named Horace Mann is probably the one that we should all give credit for the notion of free public school, which, although it is challenging to say in this particular moment, he actually stole from the Prussians. In any event, good ideas come from all kinds of places. So around the era of the Civil War, black folks were pretty much not only not permitted to attend public school, they were not permitted to receive any form of education in general. And so there were a number of schools established to educate slaves, but for the most part, they were underground, they were secret, they were private, and many states would punish African Americans who were receiving education or anyone who provided it. So one of the very fascinating components of the Civil War was that General Sherman and General Grant were two of the first to actually found public schools to educate black folks with the idea that as part of the movement to win the Civil War and end slavery, that providing education was a core component of it. And then, of course, you get the Reconstruction era, and then I want to get the name right. We usually think of it as the Freedmen's Bureau, but the full name was the Bureau of Refugees, Freedmen, and Abandoned Lands, which was a huge, huge public works project in the Reconstruction era that did a number of things to help tried to help establish equality for a newly enfranchised class of people in this country. Among other things, they did a huge amount to establish schools. They established over 1,000 schools in the nation. They rented buildings, they provided textbooks, and they actually provided police protection, military protection to those who were violently opposed to literacy for black folks. So that was the era in the Reconstruction era when you began to see a real value on the freeness of public education and the access to public education for everyone as a core component of citizenship, of liberty, et cetera. And that's also the era when you start to get new state constitutions, which include the word free. And free is a core promise to the newly freed slaves. So, for example, the Mississippi Constitution of 1868 says, as the stability of a republican form of government depends mainly upon the intelligence and virtue of the people, it shall be the duty of the legislature to encourage by all suitable means the promotion of intellectual, scientific, moral, and agricultural improvements by establishing a uniform system of free public schools, etc. Virginia has very similar language. These constitutional provisions were actually specifically, well, we argue in a lawsuit in Mississippi, codified by their full readmission to the Union. Of course, Mississippi then, within a couple of decades, began to strip all of that out of its state constitution, and now at this point, the Mississippi Education Clause basically says, should the legislature wish, if the moon is full and it feels like it, it can kind of provide education to some people. The language is a little more formal, but it's really not that much better. But the freeness was a common theme in the Reconstruction era, and it had real effect. By the time you get to 1871, you had over 54,000 African-American children attending free public school, which is just remarkable in a place that had considered them chattel within a decade. So providing free education is one of the most transformative choices we've made as a country. But we are continuing to erode the freeness of public education as privatization increases across the country. So just as a couple of core examples. So we tend to think of, and much of federal and state law considers charter schools, for instance, to be public schools. But charter schools are not free the same way that most traditional public schools are free. So we think of free as not requiring tuition, and that is certainly part of being free. But there are all kinds of other, schools are the hearts of our communities, the locus of so many social services, and so much of that is not necessarily obligatory in charter schools, let alone private voucher recipient schools, virtual schools, homeschool, et cetera. For instance, free and reduced meals programs. I'm going to get the stat right. Nationwide, about 40% of public charter schools do not participate in the federal school breakfast and lunch program. That means there are a number of states, including California, that specifically exempt charters from participation in free and reduced meals. That's going to cost families hundreds, if not thousands of dollars a year in providing meals that are supposed to be provided free for your attendance in public elementary and secondary school. Transportation is another really big deal in this context. A huge number of charter schools do not themselves provide transportation. They rely on their local school district to provide transportation. A number of states, including Arizona, Arkansas, Washington, and Wisconsin, their state laws do not require charter schools to provide transportation at all. So again, hundreds, thousands of dollars, significant input from parents to actually access that form of ostensibly free public education. Then there are just really bald-faced obligations for parental contribution. Now, no one requires parental contribution, truly, in public charter schools, although a number of charter chains ask for parental contribution. The Basis Charter chain, which is one of the largest in Arizona, asks for a $1,500 a year contribution to help pay for teacher bonuses. There's another charter, I believe this one is in California, that asks for a $3,000 a year contribution as well. Those are not small amounts of money, and certainly not small when you're talking about a free public education. And that's to say nothing of forced volunteerism. This is a really common theme among charter schools where you are obligated as a family to volunteer your labor, typically about 40 hours, which, for working families is 40 hours of unpaid labor that you are providing, and it has value to your school. There are states such as Florida that actually permit volunteer mandates for public charter schools. So back to forced labor, I guess. So these costs, of course, are, they pale in comparison when you look at charter schools compared to private schools. The average cost of private school tuition in this country is over $10,000. There are almost no voucher programs that provide that amount of money. Typical private school vouchers are between $4,000 and $7,000. There are some places that provide up to $10,000. But that is to say nothing of, for instance, the cost of educating a student with a disability who, under the Individuals with Disabilities Education Act or under Section 504 of the Rehabilitation Act, would receive services that might cost tens of thousands or hundreds of thousands of dollars in the public system. Of course, LEAs and SEAs are obligated to pay what's called a proportionate share of their funds to private schools to educate children with disabilities under federal law, but there is no individual right for children whose parents place them in private school to receive the kind of free, appropriate public education that they receive in public school, and certainly things like getting evaluations, all of the obligations that are quite costly that public schools bear just don't exist in private schools, even though very often in all of our states that provide vouchers to private schools, you are getting some form of public money subsidizing this form of education. So I will conclude on my, my thoughts on the freeness of public education simply with the thought that, you know, we have, as litigators, as scholars, we have focused on many of the other core components of public education, on its thoroughness, its efficiency, its quality, a number of different phrases that you hear throughout state constitutions. But I do think that going back to the freeness of public education is a core aspect that we can't forget. Freeness is what actually made public education accessible to the vast majority of people in this country. Education was accessible, as well as laws against discriminating on the basis of, race and sex and what have you. But freeness was an incredibly important component of that as well. And as we continue to see programs that call themselves public but are not in fact free, or programs that use public money and are not even remotely free, that thinking about challenges in that regard, that's going to be an important avenue because we have, in many ways, lost the fight with the idea that these programs are public, but the freeness is still an open question. And so for all of you future litigators out there, think about that both here in West Virginia as a means of protecting your state against privatization and in other states across the country as well.
Thank you, Zoe. And Mark, I had a question for you, but at first I want to just check in to make sure if anyone has a response or wants to comment about what Zoe or Scott or David said before.
Well, again, just in the interest
Yeah,
of having
yeah,
a conversation,
please.
I just want to, I'd rather also talking to each other. I just want to highlight, I think Zoe's points are really powerful, especially, one of the things in thinking about Pauley, and like my colleagues, hadn't read it in a long time till got invited. But, and one of the things, not to take away anything from the power of that decision, but thinking about how the nature of education, public education, broadly speaking, has changed since then, right? So the Pauley court wasn't confronted with the impacts of charter schools or private school vouchers. And so, and just thinking about the issues that Zoe was raising, when one of the, besides the obvious fiscal impacts of those programs and what they take away from the traditional public schooling is, the questions about students with special ed, students with special needs, there's that aspect of the impact of those alternatives leaving who's left behind in the traditional public schools, typically the hardest students to educate, right? The students with special needs, the students who have experienced the adverse impacts of poverty and come to school, bearing a host of burdens unrelated to their schooling, opportunities for pre-K, opportunities for other socialization. And so, it's not just the funding implications, which is what a lot of people think about when they think about charters and vouchers and how they're taking money away, but also how the substantive change in who's attending the traditional public schools and how that impacts the state's ability to provide, in North Carolina, we call it a sound basic education, an adequate education, a thorough, efficient education that, in some ways, Pauley is this really brilliant, shining example, but it's also important to keep in mind how much the universe of education has changed since then and how it presents a different host of challenges related to funding, of course, but also just related to being able to provide sufficient education.
So I want to pick up on some comments about Pauley, what Pauley didn't do. And I think, Mark, you talked about it, which is the issue of the disparity and a word that I think we also lose sight of, other than free, in these constitutional provisions, is the word system. These are supposed to be systems that the state is obligated to provide a thorough and efficient system of public schools. And so that has enormous implications for the kinds of issues that Zoe is talking about, that we see now, which is the states essentially creating parallel systems of schools that might not be totally free, that are under lots of different standards, can be free from a lot of the requirements that you see in public schools and free public schools, so forth and so on. So that's a really important word that we also don't talk about. And I think the Pauley court was concerned about that. I mean, that was a huge issue with the court, which is this is a system that needs to be available for all West Virginia school children, same way that the Rose Court talked about it in Kentucky. The one point, though, that Mark's point that Pauley sort of, I think, hints at a little bit, but because of the time didn't get to, which was really picked up in Abbott, and cases like Abbott or the Kansas case, and cases that we've seen since, and that we now sort of accept in a lot of the discussion of what education rights should mean, whether it's in court or in the legislature and so forth and so on, which is the notion that poor kids need more. I'm going to just say it simple. And I think that the Abbott court is the best on this, really. That the idea that to have a thorough and efficient system of education, the system can't have disparity in educational opportunities, resources, and outcomes for vulnerable groups of students that need more when they come to school. So that notion really was not really developed in Pauley. Mm-hmm. They sort of talked about it when they hinted at the supplemental funding piece. Right. Yep. They said, they were kind of getting at that, mm-hmm. But this is 1979. Fast forward to 1991, when Abbott versus Abbott II comes down, it's a shockwave. Because Rose was really about the entire system underwater. Abbott was about disparity, what Mark is talking about. Mm-hmm. A state, New Jersey, in which you had some of the most powerful, highest performing free school systems in the country, alongside schools where the state allowed systems that were literally next door, that were falling and crumbling apart, systems that had to educate large numbers of kids who came to school with additional needs. So you get to Abbott, really fills in the gap, which is the system also, from an adequacy or equity, this is where equity and adequacy really kind of come together, which is the system also has to make it, and this is I think the challenge in West Virginia today, and in a lot of states that have had good rulings, but they really haven't grappled with the core issue of what does a state have to do to fulfill its constitutional obligation to make sure that if the state is going to run a system in which poor kids or kids of color are concentrated in huge numbers and high numbers in a subset of schools within that system, what does adequacy look like? Abbott answers that, and cases since that sort of answered that unanswered question in Pauley, and Rose, I would add, really gets to the issue of this notion that if you come to school with additional educational needs, the state has to, and the state is essentially, through its governance mechanism, allowing that to happen. Keep in mind, the question of where you go to school and how district boundaries are drawn, or whether we have charter schools or not, are actions by the state through the legislature in the performance of its constitutional obligation to run the system. So we really have to get our minds around that. So the whole landscape of West Virginia, what it looks like, this system, is a creature of policy. It just didn't happen. Well, there's other things that influenced, obviously, discrimination and housing patterns and all of that. But the decisions of how the school system is set up is a decision that's made by the legislature in the performance of its obligation to run the system. So I just want to make the point that where we we need to make the point that Paulie didn't get at, but sort of laid the groundwork for other courts in New Jersey and Kansas and other places, and now in current litigation, Mark's case in Pennsylvania now that's going forward, Delaware, if you look at the Delaware complaint that was just filed, this is all about the system not providing the additional resources, the additional supports, the additional interventions that school systems within the state, local school districts within the state, have to provide where they're serving large concentrations of low-income children, children of color, English language learners, and children with disabilities. And that's the sort of real struggle today, I think, in a lot of our fights, is that we have these systems that have evolved in which the state, through its education policies and through other policies, have created local school systems that where the load, I mean, when you think about it, the educational load on the teachers and the schools from having 60, 70, 80, 90% of the children coming through the door coming from households that are below the poverty level, large numbers of kids coming into school who need to learn English in school, kids who are coming from neighborhoods with a lot of problems. The question today, really, that we're grappling with is, how does a state fulfill its constitutional obligation, whether it's through legislation or through a new funding formula, or how does a court approach this in terms of enforcing constitutional rights to make sure that vulnerable populations of students that are the ones that are not getting what they need, get what they need. And that's a sort of hinted at in Pauley. Rose really didn't grapple with it because they just threw the whole thing out. But then you get to Abbott, where it's really about the system having these very disparate allowed to have, through its funding mechanism and other policies, essentially school systems that are well-resourced, high-performing. Kids are coming from affluent backgrounds, already have advantages, alongside school systems that are struggling with less resources and great need. That's probably the number one problem or fundamental structural issue in American public education today that we've got to grapple with.
You know, I'm really glad that you focused on that word system, because I actually think it pulls us back to the first question that Josh asked, which is, what is the nature of education, the right to education? Right. And I think this is where I say the thing that maybe makes me an iconoclast here, and that is, I'm not sure there is a thing that we can refer to as the right to education in the sense that it is a positive individual right. The reason I think that is because state constitutions, with the possible exception of Wyoming's, don't mention anything about rights in their education clauses. They mention duties. What we're generally enforcing in these cases are duties for the legislature to provide for a system-wide, which is why I'm really glad you focused on that word, for a system-wide organization of schools that educate the public. And when we litigate these cases, we generally are challenging something systemic. In Abbott, it was more of systemic inequalities from one district to another. In Rose, it was a systemic inadequacy that resulted in no bathrooms in schools and rats running across the floors and things like that, right? So when we think of these cases systemically, there's a natural problem that arises, and that is the problem of constitutional conflict between two co-equal branches of government. Now, I started out when I was writing about this stuff thinking that these cases should just never be justiciable because the terms in state constitutions are so malleable and so subjective that how could you possibly hang your hat on any of them, right? And I've come gradually to the position that justiciability is required at some level to make sure that constitutional language isn't a nullity or just auditory or just sitting in the Constitution for no reason. But we wrestle with this problem in every one of these cases about how far a court can go in telling the legislature how to perform its core function of taxing and appropriating money, which is what at bottom this is really all about, taxing and appropriating money. And we're seeing this play out right now with the national emergency crisis, right? How far can the president go in overruling Congress's decision to tax and appropriate money, all right? So these constitutional conflicts are not unique to the school funding area, right? So taking seriously the question of whether there is a right to education, I think there's space for one. I'm just not sure that in any case we've actually recognized one yet. And the reason I say that is because of the way that the cases are formed and the remedies that are ordered. The remedies that are ordered are usually systemic remedies that go to the legislature and do not direct any sort of remediation to any particular plaintiff or any particular group of individual human plaintiffs. Typically it's districts, typically it is directed at the state. So what I've proposed in a recent piece is that maybe we sort of think about these cases differently and potentially solve two problems at the same time, but do a lot of hard work along the way in doing so. We've been doing this stuff for 40, 50 years now, and the system has progressively gotten better in some places and worse in other places. I'm a pervasive defender of the U.S. education system against these nation-at-risk people who think that we're all going to fall into ruin due to the horribleness of our education system. By and large, it's a good system, but there are pockets of it that are very bad, right? So thinking about those pockets where things are bad and taking the idea that a right to education may exist as a correlative to the duty of the legislature to provide an education system, why not litigate these cases individual by individual? This deals with Mark's problem, the problem that Mark identified, that we have problems that exist in our system that at least either didn't exist at the time of Pauley or were not on the radar screen nationally at the time of Pauley. Of course, we had kids with disabilities at the time of Pauley. They weren't on the radar screen the way they are now. Of course, we had people trying to privatize education at the time of Pauley. That goes back to Brown versus Board of Education, but it wasn't on the radar screen in Pauley, right? But we have individuals who are being harmed by these new movements today who are in systems where other individuals are not being harmed by these movements. And it makes the most sense to me to focus on the individuals that are actually being harmed and make those people individual plaintiffs and try to garner individual remedies for those plaintiffs such that we have enough cases at some point where the legislature moves on its own without a constitutionally conflicting order from the Supreme Court to make policy in a certain way. That the legislature recognizes, oh my goodness, there's all these cases out here, all these kids are winning, we need to start doing things differently and change the way that we're funding the system. And I think the other, and I'll say one more thing about that, I think the other potential benefit that can come from that, which is the thing I'm interested in, is the malleability and the subjective character of state constitutional language. Doesn't mean it can't be interpreted, but it does mean that interpreting it in one broad swath in a systemic ruling that says thorough and efficient means this for all time, this list of 8 things, is dangerous because we could be wrong about that. Education policy changes over time. And I think the better way to do that is incrementally the way we develop the jurisprudence on words like due in the Due Process Clause and cruel and unusual punishment in the Eighth Amendment. We do it case by case because those are terms that don't have any sort of obvious objective meaning to them. We have to give them, we've got to give them skin on the bones, and the way you do that is through common law jurisprudence. So anyway, there's my soapbox that that builds from what you all are saying there.
It's interesting that, a couple of things in that, just on the building individual cases. So we just lost a case at the North Carolina Supreme Court where we brought a Leandro, a state constitutional education claim on behalf of students in Halifax County. It's one of the poorest counties in North Carolina, and it has 3 separate school districts for 6,000 kids. 2 are all black, 1 is almost all white. And we brought the suit against the county commissioners. We brought it as they have local funding responsibilities. They also have the power to consolidate the districts. And we lost that case because the Supreme Court said, you sued the wrong person. You should have sued the state.
Should have sued the state.
That these are state, this is a state responsibility, and any change that's going to be made around the constitutional right to sound basic education is going to be made by the state. And it's interesting because when we brought that case initially, we had allies, education advocates, who said, you shouldn't bring this case. We want the state to be responsible. We don't want to have to go and file 100 lawsuits in 100 counties to push this, like what happened during desegregation, right, where you had to bring these cases district by district. And we took the alternative theory and said, no, the facts in this case are so outlandish that this will get, the theory was exactly what you described, Scott, and the court just shut that down. Also, we've been frustrated by the stalling in the Leandro case, which was another reason we wanted to avoid getting caught up in
And
that.
that's another purpose for me suggesting this, because
Right.
we keep going back to the state Supreme Courts for ruling after ruling after ruling, you know?
But David's construction of, would really, I wish is this being taped? Because I'd like to have your laying out the current state of the problem and the, you know, how we serve, in North Carolina, they call them at-risk students, but, you know, this subset of students who have these additional challenges for education, how do they get served, and that it's going to require different levels of funding to serve those students. That's really what the issue is now, but the courts continued, I think, to wrestle with it along this separation of powers. You know, in the Leandro case, the court agreed over and over again that the schools were failing students, that they, you know, at one point the judge, you know, called it academic genocide, what was happening in some of these high poverty districts. But then stopped because of this, which is also forecast in Pauley, this separation of powers idea, that, you know, if the remedy is really just a financial one, we're limited in what we can do. And I think it points out, one, I think that's a misconstruction of what the court's power is. We can talk more about that. But it also highlights, I mean, the truth is, there is a political aspect to this, right? You know, the teacher strikes that we're seeing, which I know the next panel is going to talk about, changed the dynamic, right? Produced more reactions from legislatures in many states than a lot of the legislation has. Certainly in North Carolina. You know, it led to real consideration about at least teacher salaries and teacher funding. And so there is clearly this political component to it that has to play a role alongside the litigation if we're going to transcend this separation of powers, you know, fig leaf that the court continues to hide behind. At least in North Carolina, hid behind for, you know, 15 years.
If I,
Yeah, please.
I just a quick point. So in terms of where we are today, sort of to fast forward. So the real issue is the advent of standard. I want to come back to standards-based education because, and this idea, this really modern notion, it's only in the last 20 years that states have prescribed substantive educational standards that all kids have to meet. Think about that. The state, in its performance of its duty to implement, if you will, or run, or provide a system of free, thorough, and efficient public schools, has now legislatively prescribed substantive standards that, and look across any state, and you see in statute and rules and regulations requirements for curriculum requirements. All the things that are in Pauley are now in statute, and even more, right? So assessment systems, disaggregation, performance data, disaggregation of data by racial and socioeconomic subgroups, accountability measures, right? So I think what we have to start thinking about, whether, and this is particularly important in the State House, is the political piece, is that we have to be going back to these legislatures and saying, look, if you prescribe these substantive mandates, whether it's kids have to read, I've seen statutes in, you know, South Carolina legislature just put in a whole bill. It's you know, wonderful mandates. The state mandating on local school districts, kids have to read by 3, they have to be literate, all of these things, right? States have, legislatures have gone all in on it. And what I don't think we've done is sort of put this in a constitutional framework when we're in the politics of this. If the state is going to mandate substantive educational standards that all kids must learn, know, and meet in order to be proficient or college and career ready, whatever that standard is, that's the legislature fulfilling its constitutional obligation. And the point of this is they've got an obligation not just to mandate, to provide unfunded mandates. They've got a mandate to provide the funding and resources that are sufficient or adequate to give these school districts and these students to achieve the very standards, substantive standards that the state is prescribing that they meet. That's a constitutional. We don't talk about it in constitutional terms, but we need to. So when you go down to the West Virginia legislature, somebody said that some legislators were dissing Pauley the other day. people need to be standing up and saying, no, look, Pauley's good law. Till the Supreme Court overturns that, that's good law. And what that means is that if the West Virginia legislature is mandating all kinds of substantive requirements that local school districts have to meet, including, what teachers have to meet and what their qualifications should be and so forth and so on, the legislatures have a concomitant obligation, constitutional obligation, to have a financing system that is built on the cost of delivering those standards for all kids, and that includes the additional costs that kids who have additional needs have to have. If we don't come to grips with this, Scott's point about when Trump came in, I wrote something about, I was telling Governor Wise about this last night. Trump comes in and people are getting all worked up about what's going to happen to the federal role and all of that. To me, it's always been that way. And my advice was, okay, we're going to have an administration that's not going to do anything. And we've seen it. I mean, I'm overstating it, but they're just checked out. States, it's back to the states now, as it has always been. So my advice is go back to your state and enforce the constitutional right in your state constitution, whether you do it in the courts or you make the case in the legislature. These legislatures have to understand that if they're going to require kids to meet certain academic standards and so forth and so on as a part of the state system, they're performing their constitutional duty fine, but then they can't just turn around and say, we don't care about the money or we're going to cut the education budget. So we have to kind of think more broadly about what does the Pauley mean today in the current constitutional, current context we're in, educational context we're in, and how do we use those constitutional, how do we actualize those so that they're not just decisions in a book, but they're used when we go down to the West Virginia legislature and talk to the committee about their responsibility to make sure, look, if you're saying that kids have to, meet these standards or so forth and so on, or provide this or provide that, you have an obligation to make sure that that your system is delivering the resources that gives teachers and students and schools the ability to actually achieve the very standards that you're mandating they meet.
So we can talk, oh, go ahead, Zoe.
Just very quickly to go back to the individual rights question, just to put on the table, the federal system is not generally good on this front, but it did ring a bell for me about Goss and about the question. So Goss v. Lopez, of course, is the case that holds that depriving children of education without due process of law is a Fifth Amendment problem. And so thinking about individual rights litigation under state constitutions through the lens of Goss is a way to go at this question.
Of course, that just gets us to negative rights, though. And what I think all these folks care about who are litigating these cases is positive rights, right? Rights to receive things from the government rather than rights to prevent the government from taking things away from you, right? So definitely, yes, the negative rights definitely exist, but that's a right that is a right of basically property or liberty. And it's not really a right to education. It's a right to not have your education taken away from you once it's given to you, right? So the thing I'm interested in is, do you have a standalone, freestanding right to education that doesn't depend on somebody taking it away from you, that actually allows you to compel the government to give it to you, right? That's the important question here when we're thinking about whether there is a right to education. Otherwise, there's a right to due process, which is what you're talking about. That's a right to due process, not really a right to education. It just so happens that the property or liberty interest in that case is an education interest. It's not a right to education. So it's not the kind of right to education that I'm referring to when I say that.
But Pauley talks about being free from discrimination and so forth and so on, in West Virginia.
And I don't think there's anything controversial about
No,
that.
but the point, you're making a really good point, both of you, which is around what I was just saying about what's the legislature's constitutional obligations for the system. Obviously, I was talking about money, closing the loop, not just mandating standards, but providing the resources. That's critical. But it also extends to things like discrimination requirements and due process requirements in school discipline, school-to-prison pipeline issues. There's a whole host of issues that we sort of think, oh, these are federal matters. No, these are matters of the right to a fair and efficient education is defined by Pauley, includes the right to be free from discrimination in the system. how do we operationalize that? How do we get the legislature, let me put it this way, to operationalize that in state statutes and rules that ensure substantive, due process for individual kids, access to services for individual kids, heightened standards of discrimination. Because keep in mind, states can go in this field, because this is a state right.
Sure.
State legislatures, and they do, go far, far beyond what the federal government provides. And I just don't think we around the country have really grasped. One of the things that I go around the country and do a lot of this, it's really hard to, and talk to reporters and all of that. People don't understand these are state systems. We have no national system of education, and we're not going to have one. Sorry, Derek. No. And so how do we get people to understand that the condition of education in West Virginia, how West Virginia kids are doing, is a responsibility of the state legislature, not Washington or not another state. And how do we deal with states? The problem in our country is, and Zoe has heard me talk about this, our problem in American education is we have some very high-performing state systems. But we have whole regions of the country, states and whole regions of the country, if you want to think about it this way, that are dragging the whole country down academically and educationally. Because they're mandating all these standards and they're disinvesting, they're not providing the resources or the individual protections and other things you need to run a high-powered educational system. That's only going to be solved in the State House.
Well, and I just want to say on the individual, North Carolina, the court said that it is an individual right, that every student has the right to a sound basic, opportunity for a sound basic education. They didn't identify.
A lot of them use that rhetoric.
Right, they do identify it as an individual right, and then the fight is, what does that mean, right? What is a sound basic education? And you start with early decisions that say, to be able to read and write in English, to know math, to know social studies, to be able to be a citizen, or to be able to be meaningfully employed. But it is described, at least in those opinions, as an individual positive right.
Yeah, that's absolutely right. Yeah.
And so, and then we get into this fight about what does that mean, right? And then what does it mean to provide the opportunity? So I think I think it's there in these opinions, and then the struggle comes with how exactly what David is describing is. And what is, there's been this resistance to sort of making the connection between just funding and and how these opportunities work together, right? So they do have these mandates, right? In North Carolina, a few years ago, they passed this Read to Achieve law. You have to be able to read by 3rd grade, and if you're not, you get held back. And they passed it 4 years ago, and what they found, so that in those 4 years, the number of students who can read in 3rd grade has gone down because the schools have been starved for the resources they need, particularly the schools with the students with the highest needs. And so what we're expecting is not more funding, but that the law is going to get changed this session to soften the requirement, right? So, but I do think that that making that connection between these mandates and then the availability of those resources, and you talked about it, David, as it's not just between districts, right? We see it in North Carolina within districts, right? So you have, because of the legacy of residential segregation, you have, schools schools in West Charlotte are all high poverty, racially isolated, low performing. Schools in North Mecklenburg County are overwhelmingly white, they're upper middle class, and they're high performing. And when Charlotte Mecklenburg School says one of the things we're going to do to start addressing that is we're going to redraw the lines, the towns, the predominantly white towns in North Mecklenburg said, we're going to set up our own charter school systems so we don't have to go through a reassignment. So those are that aspect of that engaged, engagement around the equitable distribution of resources remains powerful and potent and continues to be driven by issues of race and class. That we've got to be able to come to terms with. And, the other aspect, and I know someone's waiting to talk, but I just wanted to get this in quickly. It was something, going back to the free stuff that Zoe started with, just to put a zoomed out umbrella over all this. When we're talking about public education, Nicole Hannah-Jones has talked about this, other folks the folks at the Haas Institute, John Powell talks about this, is, what's being taken away is the public aspect of public education, right? It's no longer being recognized in large quarters as a public good. And so what we're seeing now is this, with this privatization of education and the marketization, is this idea that the only measure of educational accountability should be parental choice, rather than the public interest. And what these cases are about, when they talk about a sound basic education or an efficient or a thorough education, is talking about maintaining the public good in education. And that, I think when we're going to the legislature and pound it on the desk, one of the things we have to talk about is the legislative, support, the legislature putting its, with all these programs, by starving the funding resources, is the legislature's putting their imprimatur on people being able to withdraw from the public space. So that's my soapbox.
Thank you guys, because this has been fascinating. But you all have touched on various times talking about vulnerable children, vulnerable populations, and also talked about like regions of the country that are bringing things down. I primarily work with the special education program at Legal Aid West Virginia. And one thing we're seeing, especially in our southern coalfields, but given that the majority of you are primarily from the south, I'm sure you're seeing it too, is with the opioid crisis and what it's doing to our school systems. We have counties in the state where more than 50% of children are not being raised in a natural home environment. They're in a kinship care provided environment, and they're coming from some sort of trauma, which of course then increases the likelihood that they have a learning disability or a behavior disorder or a diagnosis of some kind that would qualify them for 2419. And I just wondered what you see when you're talking about individual cases versus systemic and federal and state kind of juxtaposition. Is there possibly not under the current federal administration, but do you think that there might be this time when these counties and these states get overwhelmed with their special education population and their child find responsibilities, that there will be a federal suit under IDEA that puts more of a burden on these counties through the state constitutions?
David, I think you're
Well, I'll make a
One
quick,
who's most
a quick
closely
mention of the,
associated with these
we're
cases.
doing litigation in Flint over this, and we have a class action that we brought against the state of Michigan over the situation in Flint around special education. So you had a district that essentially was falling apart before the lead crisis in terms of the delivery of special education services, its child find responsibilities under IDEA, so forth and so on. Chronically underfunded by the state. Huge hole in the special education budget every year, which is something you see structurally in a lot of these state financing systems where special education is, it's mandated by IDEA, gets the resources, and then, the districts have to reallocate within their budgets off the general fund, so forth and so on. So we confronted, what do you do? I think you're asking this question in a broader sense. What do you do in this case, in Flint, when the entire school-age population has been exposed to lead, which is a potential factor contributing to disability? So what does child find do in a kind of systemic, we've never really IDEA never really, when IDEA was, nobody thought about this, right? That you could have a situation where every single child in that community was at risk of, not that they're all going to, require special education, but is at risk of a disability, and what kind of child find system do we need? I think we've got to start pushing on this in terms of the existing law. I don't think Congress is going to help us out here anytime soon, but there's a lot that you can do. What we wound up doing in Flint was a settlement in which we created essentially a new child find system because we knew the district couldn't handle it. They just didn't have the capacity, the child study teams, the so forth and so on, to just do the child find properly. So we basically engaged the health community in Flint to do it. And so now if you live in Flint and your kid was exposed, you can sign them up online in a registry. There's a screening that goes on. if there looks like you need to get further evaluated, you're referred not to the child study team, but to a center, health center, and then all of those results go back to the school. And we just started this, so stay tuned. I don't know how it's all going to work out. The second part is about trauma. So this gets to something that the Abbott court said. It just, to me, is something we should try to put in our heads. The court was grappling with the question of, that we talked about, what's the, and this is the sort of bedeviling question in school finance, what are the additional resources and what do they cost for kids who are at risk in these high poverty school districts? And we need a lot more research in this area from educational researchers. We know preschool, got to get them in preschool. We don't get them in preschool, they're already behind. So that's something that has to happen in terms of meeting the need. But there is this question we need to do a lot more work on, and I know Zoe and others are looking, which is what are the interventions that high poverty schools, like the ones you're describing, that have a lot of trauma and other things that are happening to kids outside school that affect their schooling, what are the program staff and services that they should be providing, either directly or through collaborations with community-based programs, that will, and this is the way the New Jersey Supreme Court said it in Abbott, that will wipe out the disadvantages that these children bring to school as much as a school can. That's a term of art that research has to, so what we need is assessments of what are the needs of kids in these trauma places that you're talking about. We've got to get the State Department of Education down there to figure out what are the interventions what's the impact of the opioid crisis in these communities on kids' educational opportunities? And what do we need to do with schools to ensure that they have the interventions they need, the staff and the supports they need to address these disadvantages? Because if they don't have them, all it's going to do is, burden the teachers and the principals and so forth dealing with, crisis after crisis. So that's a really important issue that we have to keep pushing on, which is this notion of what can we do in schools? What is reasonable to do, given the fact that unlike other school systems in nations around the world, we don't have a decent social safety net for kids, right? So the schools are left with, unlike in France and other places, they don't have to worry about homelessness and all of these things. We do. Schools have to. So that gets back to the resource question and connecting schools to community and all of that.
Well, and our other question here, I know you guys have it in Kentucky, I'm sorry.
Homelessness.
Is, well, not just homelessness, but, we have counties where they know a referral needs to be made to the medical community, but there are no providers within a 3-hour.
Right.
And I do want to just note for the record that I agree, David, that asking the school system itself to do much of this is probably not feasible, but we do have an incredibly important law in this space, which is EPSDT. For the folks that mostly do education work, this is the children's component of Medicaid. It stands for Early Periodic Screening, Diagnostic, and Treatment. Why it's diagnostic and not diagnosis, ask someone in Congress. But the EPSDT mandate is, I would say, the single most important underused legal hook in this context. Schools are Medicaid providers. Public schools are Medicaid providers. They can bill and should bill Medicaid. A huge number of schools do not bill Medicaid for any services because they don't have a Medicaid biller, which is an absurd reality that puts, form and administration over access to services, especially because so often you have between a 70-30 federal-state match to a 90-10 federal-state match. So there is an enormous pot of money that is sitting there that is already appropriated for state and local use through the Medicaid system. And so I would say, when it comes to things like diagnosable complex trauma, let alone any other number of qualified disabilities under the Medicaid Act, you do actually have access to an enormous system of services. It's just that actually braiding and blending Medicaid funding into the education system is so rare. I'm truly, I mean, only New Mexico has a statewide effort to do this in the way that you would want to see, and they're still radically underfunded for everything else in education, as the folks litigating that case would tell you. But I will just sort of put a marker to say we don't need a new law saying that kids with the sorts of disabilities or disadvantages that you're talking about have a right to services. We have one, it's just not enforced.
And the Flint Child Fine universal screening and evaluation process, we put it outside of the school system, in the health system, with the connection to the schools, precisely for this reason. So the federal government would pay for it.
We have time for one question.
I'm here to give a ray of hope. This has been fabulous. I have loved hearing this. I came to West Virginia almost 40 years ago about this time, and my children were part of the public school system for a short period of time. And I do special education law, I do all these issues, and you have done such a great job of framing this. And here is the hope, is like you have, I think, correctly identified, is that state legislators have to realize that they have to fund this. And here's the ray of hope. I watched the elections last November, and I see state legislators changing. I see them understanding it. The role that universities can play is helping to have them define, connecting those dots about why not spend this money up here, or you're going to spend $40,000 per person a year in the prison system. I mean, that's a little bit simplistic, but and I see 3 of my former students from University of Louisville in our state legislature, and they're fighting for these issues. And I am hopeful, and Mr. Rogers said, look for the helpers, and I am hopeful that we have helpers. And it's not going to happen overnight, but I think conversations like this really help to move that forward. So thank you very much.
Yes, thank you for ending on that highlight. I want to thank our panelists, of course. Thank you for, this has been an excellent spirited discussion. Can we all give them an applause, please? So I wore my red for Ed tie today in anxious anticipation of our next panel. And as we invite our next panel to join us, I wanted to draw our attention to a short clip here of one of our courageous and inspiring West Virginia teachers.
Pocahontas County is one of the most rural counties east of the Mississippi. It's over 70% state and national forest. There are huge pipeline problems in West Virginia. Right now, around 40% of the classes in grades 7 through 11 are taught by uncertified or undercertified people.
Oh, look at the spells on her now.
So you have to wonder in that setting, are you really providing free and equal education to everybody? If some people are expected to learn mathematics from someone else who doesn't necessarily know mathematics. From the first maybe 2 years, 2 years into teaching math, I really started watching kind of the horizon of how schools do or don't support teachers to get better, and how odd it is that teaching and learning is such a community exercise, but there really isn't community among educators in secondary math. So I'd been kind of building my own change theory for, 8 years or so.
Yes, don't you think yes? I mean, we're just developing this right now. So don't you guys think yes?
It seems
That'd be
cruel
super weird,
otherwise.
yeah.
The 2 main things that I'm up to are either working with individual teachers in their classroom. So I really believe in embedded professional development. So either I'm modeling a lesson that we're trying to work on together, or the teacher is, and either way we're giving each other feedback on the same set of questions. Or I'm organizing and orchestrating teachers to work together.
Architect's direction here, the pre-number 2.
If you feel good about this problem, you better claim it as the architect. Like, I
So
wanna be
maybe
architect
this
on this
actually
one.
goes along like on your.
You think everything is fine, and you're on your way to be a teacher now, and you're in charge for the rest of your career in your classroom. And it wasn't so much that I'm not in charge anymore, but it's so nice to have someone to emulate and to look up to. You know, even as a teacher, I still want to be a learner.
Pretty traditional in a coaching model that a coach observes. We try to ensure that at least as often teachers are observing.
Even if what I'm asking you to do feels super awkward today, I want you to just roll with it, okay? And then at the end, we'll talk about what worked, what didn't, and what kind of changes you guys think we should make before we kind of finalize this. Does this sound okay?
Right, because it's hard to keep track of all that algebra in your head.
So compared to kind of working as a group with no structure at all, what was better about using these roll cards and what was worse?
The math program before Joanna started implementing some of the ideas that she has, we were in rows. We were in rows. Here's the math book. We started chapter 1. A teacher would get up in front. They would lecture. This is how you do the problems, and then the kids would sit and work on problems they're having for homework.
See, when you're in rows, you're kind of in your own bubble. If you do get stuck on a problem, you're kind of scared because you don't want to ask your teacher. Each of you is going to have a problem eventually, and it's slowing down the process.
Okay, so go ahead and start navigators.
Would equal whatever number, and you'd have to divide it by 250, see how many 250.
I truly don't know if I'd still be a teacher today if it wasn't because of Joanna. It's really nice to know that you have someone working so hard and who truly cares about you in your classroom, cares about your kids, but also cares about you as a person and makes sure that you're okay in your job. It's important that teachers are happy in their job so that they continue and want to, you know, spread the love of learning to their kids. I think that's super important, and she certainly spreads the love of learning to all of us as teachers.
That's what you say. You be real. That's fine. We're not judging each other today, okay? I miss teaching on a daily basis myself, and it would be really cool to think of a new version of teacher that isn't just a teacher, but is this hybrid teacher leader doing the work in their own classroom and then letting us be a little bit creative about how to get them outside that classroom and better network to other people. In so doing, I think we can retain way more really motivated and driven people in the profession of teaching and also allow them to grow one another as they learn.